So friends, Special Counsel Jack Smith just filed a new motion with Trump-appointed Judge Aileen Cannon imploring her to impose a gag order on defendant Trump. But do we really think gag orders are sufficient to protect the American people from Donald Trump's incessant violence-inducing rhetoric? Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. Well, friends, here we go again. Prosecutors trying to use gag orders to control, to restrain, to stop Donald Trump from endangering the folks who are trying to hold him accountable for his crimes. We've seen this movie before, haven't we? Well, let me start with the new motion that was just filed by Special Counsel Jack Smith. And the one thing I will give him is he does not mince words. He is direct, he is blunt, he is unyielding. And I want to read his opening salvo, but then we have to have an honest discussion about whether forever trying to restrain, control Donald Trump with gag orders makes any sense, given what we have learned, given Donald Trump's repeated violation of those gag orders with what is pretty much impunity, no real punishment. But let's start with a new court filing by Jack Smith in Donald Trump's prosecution down in Florida for, as we know, committing classified documents crimes, obstructing justice, and violating our nation's espionage laws. And let me set this up, friends, so you'll have context for what Jack Smith is arguing in this new motion. Recall that we learned from some earlier court filings that the Department of Justice, the FBI, coordinated with Donald Trump's lawyers before they executed the search warrant at Mar-a-Lago to make sure that when they went to Mar-a-Lago, when they went to Florida to execute that search warrant, to seize the evidence of crime that Donald Trump had at his Florida home, they made sure neither Donald Trump nor any of his family members would even be in the state of Florida at the time. With that knowledge, Donald Trump went on to state and post that the FBI came down to assassinate him. They were locked and loaded and ready to go, and they were also going to hurt his family members. Nothing could be a more transparent, bold-faced lie. So against that factual backdrop, let's turn to Jack Smith's new court filing in Donald Trump's federal prosecution down in Florida. In late May 2024, defendant Donald Trump made a series of false and inflammatory public statements about the law enforcement professionals who conducted the court-authorized search at Mar-a-Lago, telling his audience that the FBI was out to kill him and his family. Trump knew that this was false, and he intended that his comments would inflame his listeners. Indeed, that was the whole purpose. Comments like those create an immediate threat to the safety of law enforcement professionals, men and women who dedicate themselves to enforcing the law and protecting the American public every day, and who are entitled to do their work without fear of violent retribution. The government has accordingly moved to modify Trump's conditions of release to prohibit further statements that pose a significant, imminent, and foreseeable danger to the law enforcement professionals involved in the case. Rather than address the risk of harm that his recent false statements created, Trump's opposition focuses on his political campaign and the timing of campaign events. But the government, meaning the prosecutors, the government has absolutely no interest in those matters. None. Indeed, Trump has released a torrent of criticisms of the Biden administration and the Department of Justice, and the government has made no motion to this court to limit or address such comments in any way. Trump is welcome to make such statements to his heart's content. They are simply not the government's concern. Instead, the government's sole purpose is to protect the safety of law enforcement professionals and the integrity of this proceeding, and nothing more. Consistent with that purpose, the limitation that the government asks the court to impose is exceedingly narrow, focused, and fully consistent with the First Amendment. In resisting even that narrow limitation, Trump is left to argue that the First Amendment will be eroded unless he is permitted to lie about FBI agents intending to murder him and his family. The law requires no such thing. This is a pending criminal case, and like any other criminal defendant, Mr. Trump does not have an unlimited right to engage in speech that poses a risk to witnesses and threatens the integrity of the proceedings. In his response, Trump backpedals, struggling to dilute, parse, and reinterpret his false and intentionally inflammatory comments in order to justify them. But there is no question that his statements were intentionally false, that they were designed to inflame and anger his audience, and that he knew that his statements would do so. Every court to have examined the issue has recognized the threat caused by the long-standing and well-documented dynamic between Trump's comments and the predictable response from some of his supporters. No court would tolerate another defendant deliberately creating such immediate risks to the safety of law enforcement, and this court should not wait for a tragic event before taking action in this case. Protecting law enforcement is the government's duty, and we respectfully ask the court to address the serious risks posed to law enforcement and to protect the integrity of these proceedings. And the motion continues for another 10 pages or so. Jack Smith lays out the precedent, the case law supporting the gag order request he's making, but I want to focus on just two sentences toward the end of what we just reviewed, and it's these two sentences. Protecting law enforcement is the government's duty. No court would tolerate another defendant deliberately creating such immediate risks to the safety of law enforcement. Now, friends, I appreciate the words. I appreciate the sentiment. I appreciate the legal analysis, because there's no doubt that a gag order should be imposed. But what have we learned from prior gag orders? Remember Donald Trump's New York State court prosecution, the one in which he was convicted of 34 felony crimes he committed to try to steal the 2016 presidential election. Judge Merchan put gag orders in place, and Donald Trump violated them over and over and over and over again. And Judge Merchan found, beyond a reasonable doubt, he violated the gag order at least 10 times, and he didn't punish him at all. Donald Trump could have received 30 days in jail for each count of criminal contempt of court, 300 days in aggregate, and he didn't get a single minute in jail. What did he get? A $1,000 fine on each count. Did that have an impact on Donald Trump? Of course not. He grifted that off his base in probably 5 minutes. So we know gag orders will not stop, have not stopped Donald Trump from spewing his violence-inducing rhetoric. And his supporters eat it up and they respond. Exactly as Donald Trump knows they will respond, exactly as Donald Trump intends them to respond. So when Jack Smith says a court would tolerate this from no other defendant, he's right about that. And what we've also learned is that gag orders are useless and pointless and will not protect the people who are involved in the endeavor of trying to hold Donald Trump accountable for his crimes. But there is one thing that will have the desired effect. You already know where I'm going, friends. Any other defendant who engaged in this kind of conduct would be in pretrial detention. Why? To protect others from Donald Trump's incessant violence-inducing rhetoric. Don't the victims, the witnesses, the jurors, the prosecutors, and yes, the law enforcement agents who Donald Trump is endangering in the extreme, don't they deserve the protections of the law? Because thus far, we've sacrificed them all to Donald Trump. Pretrial detention to protect everyone, to protect American democracy, and it will have the fringe benefit of taking away Donald Trump's microphone and his megaphone. And then maybe, just maybe, these criminal cases can proceed to trial in an orderly fashion without everyone being endangered by Donald Trump's violence-inducing rhetoric. So there is a remedy for what ails us. Pretrial detention. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.